All right. Hello, everyone, and thank you for joining us on this Tuesday. I will be our host for today, and we have a great group of speakers for you talking about a variety of topics. So, Kath, if you could go to the next slide, we'll go ahead and get started. Before we do that, I did want to mention that Bond has its ongoing labor and employment conference happening. We call it our Workplace 2024 conference. We've been in several locations already. We have several locations yet to go. Rochester, where I'm based out of, is June 4th. So we encourage everyone, regardless of where they are, to come to the location closest to them. We'd be happy to see you, and it's a great program. Next slide, please. Okay, so I am your host for today. We will then be turning next shortly to Phil Zacchio. He's going to be talking about new guidance from the Office of Civil Rights. We're then going to talk to Tom about the power of attorney basics before we turn to Stephanie Fedorka, who's going to be talking about AI and the DOL's bulletin on that. And then I will round us out, time permitting, with the latest updates on pregnant worker protections, because that is a topic that we've had frequent requests for throughout the course of this webinar. So I'm going to turn it now over to Phil. Please go right ahead.
Okay, thanks, Teresa. I appreciate it. And Kathy, next slide, please. So unless we've been living on a different planet, I think we're all aware of the turmoil roiling college and university campuses and other areas in the country arising from the Israel-Hamas conflict. The federal government has engaged on this on several levels. I think we're all aware of congressional hearings going on, summoning college and university presidents. The White House has issued any number of proclamations on the issue. But the primary federal regulator in this space is the U.S. Department of Education's Office for Civil Rights, or OCR. They have been prominent in this space as well, issuing a series of guidance documents, the most recent of which is a May 7 Dear Colleague letter speaking to educational organizations and institutions, both colleges and universities, as well as the K-12 environment as well. In parallel to this, OCR has opened more than 100 investigations since October 7th, the onset of the conflict, into complaints alleging discrimination based on shared ancestry or ethnic characteristics, including anti-Semitism, Islamophobia, and others. Next slide, please. The guiding statute in this area is Title VI of the Civil Rights Act, which prohibits excluding anybody from participation or benefits in any program or activity receiving federal funding on the basis of race, color, or national origin. And in this context, national origin is deemed to be inclusive of shared ancestry, shared ethnic characteristics, or citizenship or residency in a country with a dominant religion or distinct religious identity. In particular, this is how Title VI applies to concepts of anti-Semitism and Islamophobia. Next slide. Title VI can be implicated in a couple of different ways for these purposes. One is what's known as different treatment, and it's exactly what it sounds like. The law does not prohibit a college, a university, a school district from treating students or others in a different way based on race, color, or national origin. And so typically in this space, what you're talking about are things like grading, differential discipline. In the current environment, pursuit of complaints on a differential basis has been a hot topic. For example, if an institution or a district chooses to pursue a complaint regarding anti-Semitism, but not one based on Islamophobia, or vice versa, that can potentially impact Title VI. Next slide, Kath. The bigger issue, though, currently is what's known as a hostile environment potential violation. Under Title VI, a hostile environment consists of conduct that's based on race, color, or national origin that is subjectively and objectively offensive and is so severe or pervasive that it effectively limits people's ability to participate in educational programs or activities of a college, a university, or a K-12 school district. I mentioned subjectively and offensively. OCR will evaluate this both from the perspective of the individual who's being subjected to troubling behavior, but also from the perspective of a reasonable person. And we'll touch on that in greater detail in a couple of minutes. The bottom line is mere offensiveness to an individual isn't enough. It needs to be objectively offensive in some way. And it needs to rise to that severe or pervasive level so that it's actually impeding somebody's ability to participate in educational programs or activities. Next slide, please. In that context, an institution can have liability if it knows of or should have known of the hostile environment, and if it fails to take prompt and effective steps to end the conduct, eliminate its effects, and prevent it from recurring. Next slide. So in the current environment, against the backdrop of the Israel-Hamas conflict, the biggest challenge by far has been how to deal with speech issues. Now, colleges and universities in particular have long been spaces in which dissent and protest has been not just tolerated, but actually encouraged. And this is a tradition going back decades and decades, if not longer. Now we are experiencing an environment where people are alleging that speech itself constitutes harassment. Speech centered around protests on one side of these issues or the other. According to OCR, free speech and the avoidance of a hostile environment are not mutually exclusive concepts. And you'll see the quote on the slide. This is right out of the new May 7 Dear Colleague letter. Nothing in Title VI or its regulations requires or authorizes any institution to infringe on the First Amendment, and that OCR will always enforce Title VI in a manner consistent with the First Amendment. Footnote here, public institutions, public school districts are subject to the First Amendment because they're public entities. By contrast, private schools are not, but in many instances, they promise First Amendment level protections for free speech by way of policies or student codes of rights and responsibilities, those sorts of things. So oftentimes the analysis parallels one or another. But although OCR says that Title VI does not supersede the First Amendment, they do caution, as you'll see in the second bullet point here, that merely because conduct is centered on speech, including speech that's motivated by a political or religious belief, this doesn't relieve a school of its obligation to determine whether that speech in fact creates or constitutes a hostile environment and needs to be addressed on that level. Next slide. So nowhere has this been more acute over the past 7 months than the current protests over the Israeli-Hamas conflict, and in particular, in recent months, phenomena on campus, including encampments, protests, rallies, occupations of buildings or other facilities, born of objections to Israel's campaign in Gaza. OCR, in its Dear Colleague letter, attempts to speak to this in particular, noting that merely expressing views regarding a particular country's policies or practices is not in and of itself necessarily a violation, or to not create a hostile environment in violation of Title VI, but cautions that if harassing conduct that is grounded in beliefs about a country's policies or practices occurs, for example, if it's targeted at individuals or infused with discriminatory comments about individuals from or associated with a particular country, that may in fact cross the line into a Title VI hostile environment scenario. And OCR, by its own admission, acknowledges that these are difficult lines to draw between, on the one hand, expression of views regarding a particular country or its policies or practices, which would be protected by the First Amendment and would not implicate Title VI on the one hand, and conduct that goes that additional step that I mentioned, based on students or others perceived national origin, race, or other aspects protected by Title VI, which could in fact create that kind of a hostile environment. Next slide. So to attempt to aid institutions and organizations in drawing these distinctions, the May 7 Dear Colleague letter included 9 scenarios involving what OCR characterizes as hypothetical on-campus conduct at a college or university. And according to OCR, they analyze each of these to determine whether, in fact, they would potentially impact or implicate Title VI. Interestingly, of the 9 scenarios posited, according to OCR, the facts provided in every single one of its examples would lead to an investigation. And so when you read them, you pause for a minute and say, okay, what is the differentiating factor here? What takes each of these scenarios from the realm of free speech into the realm of a situation where OCR would believe that it's got a potential hostile environment or differential treatment pattern on its hands that it needs to investigate? And really, you can distill this down into a few common themes. In each of these scenarios where OCR is indicating that it would, in fact, launch an investigation, again, adding to the over 100 that are already pending at this point, each of these involves something beyond mere political speech. In some cases, there are slurs or epithets or stereotypes or tropes being deployed and directed at people of a particular ethnic origin. In some cases, you deal with graffiti or other vandalism. In some cases, there are verbal threats targeted at people who are associated with or descend from a particular national origin, again, typically identified with a predominant religion. There are cases involving obstruction, for example, stopping people based upon their actual or perceived national origin from going to class or participating in events on campus, participating in student organizations, those sorts of things. And in some cases, acts of alleged physical aggression, intimidation, violence, property destruction, those sorts of things. So OCR is saying to us that when one of these happens, and when they are directed either individually or on a more broad spread basis toward a community based on protected characteristics of race or national origin, for example, then in fact, these are precisely the sorts of things that may implicate Title VI and will garner OCR attention. Next slide. The takeaways from all of this, you can see the struggles that institutions across the country are having, trying to draw these lines. In many respects, you're darned if you do and darned if you don't. Each of these is very factually specific. As I mentioned earlier, OCR says that in weighing whether a particular scenario or course of conduct implicates Title VI on a hostile environment level, they will look not only as to whether somebody was subjectively offended, but also whether the conduct is objectively offensive. That is really, even when stated to be objective in the eye of the beholder, including the eye of OCR. And so folks just need to be prepared to be second guessed on this. And in looking at these, really, OCR is our lead regulatory authority, but there are considerations beyond regulatory enforcement. There's the prospect of legal action, i.e. lawsuits, which you've seen in several contexts. There is the optical or reputational impact on an institution when it does something or doesn't do something, and not acting is in fact a choice in and of itself. And then there's obviously the political spectacle that we've seen unfold by way of congressional hearings and so forth. As folks encounter this on their campuses, in their environments, we are here to help. Please feel free to reach out to any of us. If you have questions, if you're wrestling with this, planning ahead is well worth the effort on this front. And to learn more, we have materials out on this. The link on the slide, for example, is a piece put out by our colleague Seth Gilbertson recently, unpacking the content of this May 7 OCR Dear Colleague letter. And with that, I will turn it back to you, Teresa.
Okay, wonderful. Thank you, Phil. That was a great summary of a very complicated and certainly relevant topic. I'm going to turn it now to Tom to talk about power of attorney basics. Tom, over to you.
Good afternoon. Thank you. So today we're going to talk about powers of attorney, which are probably a document that most people have heard of. But I want to talk about it today in the brief time that I have within two different contexts. The first context would be why somebody might create a power of attorney, what is it used for, and why might you or someone you know need one. And the second context will be if you are a third party who has received a power of attorney and asked to accept it, what your rights, obligations, and duties and the other considerations are related to that. So turning to the first, within the context of planning, broadly, usually this would fall under the umbrella of estate planning. So when clients approach us regarding estate planning, they're thinking about one day after they have passed, what ought to happen with their estate. But also just as significantly, if not even more significantly, is what can and should happen during their lifetime and what steps can they take to prepare themselves for certain things that may reasonably be expected to occur. And in this context, we're talking about planning for incapacity. The reality of our lives is that as people grow older and there could be physical or there could be mental health reasons why somebody may not be able to handle their own affairs and needs somebody with legal authority to handle their affairs for them. And in this context, the way that's done is with a document called a power of attorney. Powers of attorney are state specific. Each state has got its own laws and statutes that govern the application of powers of attorney. In New York State, the law regarding powers of attorney is found within the General Obligations Law at Article 5, Title 15. So again, fundamentally, a power of attorney is a document that authorizes someone else to act on an individual's behalf. The person giving or authorizing is called the principal, and the person receiving or the person with the authority to handle their affairs is called an agent. So there exists a principal and an agent relation between the parties, and the agent has a legal obligation to always act in the best interest or at the direction of the principal. So a power of attorney is a very important document within the planning context. The idea is that, you know, while you're healthy and while life goes on and things are, quote, normal, you always handle your own affairs and you do whatever you want with your assets and you go about your life the way you do. If you were to lose capacity because you became ill or had dementia or physically unable to handle your affairs, a power of attorney document will let somebody else act on your behalf. These are important because if you don't have a power of attorney in place, if you were to become ill and could not execute one, if someone needed to take over help you to handle your legal affairs, whether that's paying bills, buying or selling assets, instituting or defending a lawsuit, helping to run a business, anything that you individually could do, if you haven't got a power of attorney, you have to go to court to obtain a guardianship over that person in order to help them. And I can tell you that if somebody is in a condition where they need assistance handling their affairs and finances, the last thing you want to do is have to go to court, which adds a delay, which adds an expense, which adds potential difficulties to get the authority, the legal authority to help that individual. So power of attorney is a critical document that we recommend each and every person have that is an adult. Everybody should have a will, everybody should have a power of attorney, and everybody should have a healthcare proxy. So a power of attorney, again, allows somebody to handle your finances, your assets. It does not allow that person to make medical decisions on your behalf. Look, while you're competent, you always make your own medical decisions. And if you are incompetent, healthcare proxy, which is a separate document, would be used. So a power of attorney is for finances, is for assets, and it's for handling your affairs other than health decisions. So that's sort of why you would want to do a power of attorney. And when we do these with folks, we tell them, you're doing this now to safeguard in the future. Our hope when you sign this power of attorney is that it sits in a file for many, many, many years and that you haven't got to use it because that means you're healthy and things are going along well. But if you do need to use it, it's very important that it remain there. So there are a lot of, like I said at the beginning, these are governed by statute. New York has a relatively robust power of attorney statute. Other states have more or less formality. New York has got a relatively robust power of attorney statute. Briefly, there are different types of powers of attorney, but the one that's most commonly used is called a statutory power of attorney. It's called statutory because the basic template of it appears in a statute. So that's important because in New York, if you use a statutory power of attorney, certain meanings are inferred because they appear right there in the statute. So certain powers and authorities are given in there. So commonly we'll work with clients to prepare this and tailor it to their needs. They can be very narrowly construed. For example, if you're giving me, Tom Bazigian, your power of attorney to go to a real estate closing and sign documents on your behalf, you might make the power of attorney very constrained and only give Tom Bazigian as your agent the right to attend and complete all the documents necessary for the closing of my house, for example. Versus if you were trying to do long planning, you might want to make it very broad and comprehensive and say my agent can do anything. Anything necessary to help me and to assist me in my best interest. And we have a little inside joke. The form is called the New York State Statutory Short Form Power of Attorney. The statutory short form power of attorney that I use is about 18 pages long. So it's not particularly short, but it does track the statute and it adds a lot of additional authorities that we found people could need over the years. So again, these documents are critical components to somebody's estate and long-term care planning to be able to have somebody help you one day if you cannot. And then briefly on the other side, if you are someone who receives or reviews a power of attorney, a business might be presented with one, a financial institution or bank, or any number of other folks might be presented with a power of attorney. That means that the agent is using it because the principal either can't, or it's inconvenient for them, or lacks capacity to handle their affairs. In that case, if you're being asked to accept a power of attorney, certain liability exists because you have to make sure that what you're looking at is, accurate, valid, and done appropriately. I represent a number of financial institutions that accept powers of attorney frequently, and they have got whole departments often that will review these power of attorneys to make sure that they're in compliance. The reason is that if you accept a power of attorney and unreasonably act on it, meaning that if you take it and accept it and do something that wasn't authorized, potentially you've exposed yourself or your organization to liability. So if you have questions about a power of attorney that you've been presented with, it's appropriate to reach out to an attorney, and you should ask us, are there any considerations with this? Is it executed correctly? Does the agent have the authority to do what they are purporting to be able to do? So also, I'll stick in here too. In addition to, you're going to want to review the power of attorney and ask for help if you need it. There are certain specific obligations on a third party accepting a power of attorney. And one of those is if you're going to reject it, meaning we're going to say we can't accept this for whatever reason, you have to explain within a statutorily set amount of time, which is 10 days, why you're declining to accept it. So that way the agent and maybe the principal has the opportunity to explain what the concern is. You can't just sit on it. So bottom line, if you don't have a power of attorney, you probably need one in connection with your estate planning, and we recommend that you do have one. And if you're being asked to accept the power of attorney and act on it, you need to be very comfortable with the fact that the power of attorney is executed correctly and that the agent can do what they're asking to do under it. So if you have questions about this, you can feel free to reach out and we can try to help. And this is a very topical overview. There's a lot of different nuances here, but I think that's a good start. And with that, I'll turn it back over. Thank you very much.
All right, thank you. We did get a couple of questions, Tom. I'll just pitch one to you because we do need to be mindful of our time. But one of the questions we got was, if you move to a different state, would you need a new power of attorney?
So the practical answer is we would always advise that if you change residences, that you have a power of attorney and other estate planning documents that are valid under that state's law. Practically almost every state, and definitely New York, their statute says if a power of attorney is validly executed elsewhere it is valid in New York. So legally it would work, but then you've got to prove to somebody who may or may not be familiar with the laws of, say, Texas or California or wherever it came from, that it's valid. So for that reason, we always recommend, if you move, do update your estate planning documents, your will, healthcare proxy, power of attorney, so that way there's less questions of the people who would be asked to review them.
All right, thank you. That's excellent and very practical advice, Tom. Thank you for that. I'm going to turn us over now to Stephanie Fedorka, who's going to talk about AI and the DOL's latest bulletin. Stephanie?
Thanks, Teresa. Excited to be here this afternoon with you all. Next slide, please, Kathy. We're going to be talking about the United States Department of Labor's most recent guidance on the use of AI in employment. I think it's a little funny because it's a 12-page guidance document, and we'll go through the highlights together, but I think ultimately what it does, or what it intends to do, is it intends to provide some information to employers on how AI can go wrong in employment. It was issued on April 29th, and this is going to be used for purposes of compliance. Next slide, please. Hold on one second. Sorry, Teresa. I need a minute.
Oh, that's fine. No problem. While we give Stephanie some time, Kathy, why don't we go ahead to my segment on pregnant workers, and then we can come back to Steph in a couple minutes. If you could just get us to that, that would be fantastic. Thank you. Okay, so I'm going to talk briefly about the latest updates on pregnant worker protections. If I could have the first slide, please. Okay, so the Pregnant Workers Fairness Act went into effect June 27th of 2023, but recently the EEOC has published a very expansive final rule and interpretive guidance regarding the implementation of that law. So the Federal Register had that published on April 19th, making it effective June 18th, which is right around the corner, and also the day before New York's new law on paid breaks for the expression of breast milk comes into effect. So if you're looking to track it, June 18th and 19th, there's some very big days for pregnant workers across the country, particularly here in New York. Next slide, please. It's a very expansive law. You think when you hear pregnant worker fairness, it's just talking about pregnancy, and that's not true. It's certainly talking about pregnancy, but it's also talking about childbirth, past pregnancy, intended pregnancy, including infertility and fertility treatments, the use of contraception, and then, of course, labor and childbirth, as well as what the EEOC is referring to as related medical conditions, which we'll talk about on the next slide. So related medical conditions, very, very expansive list of things that the government has noted could be related to pregnancy. I know that this is a long list. Certainly, if somebody has any of these related medical conditions, these would be things that the Act would require you to accommodate them for in conjunction with their pregnancy. In looking through the list and being 8 months pregnant myself, I can tell you some of these are certainly applying to me. And of course, there's plenty more that employers would have to accommodate as well. So please just be aware that it's not just the actual pregnancy. It can be childbirth, infertility, anything related to that. And then, of course, this expansive list of related medical conditions as well. All of these things are things that employers are going to have to accommodate their employees for if their employees are pregnant. Next slide, please. So a request for accommodation is triggered usually when an employee or their representative communicates with a supervisor, a manager, someone in HR, that they need an accommodation. That can be, in writing or oral. You can't require that the accommodation be in writing, that someone uses specific words for specific format. It just has to be sufficient communication for the employee to communicate to the employer that they do need an accommodation. You may need to go through an interactive process similar to what we do under the Americans with Disabilities Act, but please keep in mind that under the Pregnant Workers Fairness Act, the interactive process is considerably more limited. You have less rights to ask for medical documentation and less types of medical documentation that you can ask for. Next slide, please. Okay, so one of the things that I thought was super interesting about this law is that the law actually sets forth what we call presumptively reasonable accommodation, which means that if somebody who is pregnant asks for any of these 4 accommodations, you can't require medical documentation saying from their doctor that they have a legitimate need for these things. These things are considered presumptively reasonable, and they include things like allowing someone to keep water nearby, allowing someone to take additional restroom breaks, allowing somebody whose work requires them to sit and stand, vice versa, and allowing employees to take breaks to eat and drink as needed. Again, these are things that you cannot request medical documentation to back up. You could for other types of accommodations that are being requested pursuant to this law, but not for these ones. And again, this is the first time I've ever seen the federal government set forth a list like this in the accommodation realm. Next slide, please. When documentation cannot be requested. So again, we have some limits on documentation. When the need for the limitation is obvious, when the employer already has sufficient information. Again, when we have one of the 4 common accommodations, the presumptively reasonable ones that were on the prior slide. When the accommodation is related to the time and place to express breast milk at work or other modifications relating to lactation breaks. You can't require medical documentation saying that this person needs a lactation break at such and such time. That is consistent with the New York law on lactation breaks as well, which also does not contain any documentation ability or requirements for employers. And you also can't ask for additional documentation when that accommodation is available to employees without known limitations. So if you're already giving this to other people and somebody who's pregnant or lactating wants this accommodation, you can't request documentation from them just because of their pregnancy or other medical condition. Next slide, please. Okay, so please keep in mind that there are differences from the ADA, which we're used to doing the interactive process under, and the Pregnant Workers Fairness Act. The employee is not required to accept an accommodation, but if their rejection results in them not being able to perform the quote unquote essential functions of their job, they may not be qualified under the Pregnant Workers Fairness Act, and you may be able to deny the accommodation or deny them the ability to continue working. One thing that's not on the slides, but I'll mention here, a leave is considered an accommodation of last resort under this law. So I've worked with some employers who have said, if you're pregnant, we just automatically put you on leave. The federal government has looked at that and said, no, you have to consider other accommodations before you get to that point. The remedies are in enforcement are the same as our other federal employment laws. You can go to the EEOC and file a complaint, after which time you can file a private right of action in court. Certainly back pay, damages, fees for emotional distress, and other compensatory damages would be available, as well as attorney's fees. So that's the latest on the Pregnant Workers Fairness Act. There's a lot to say about that. We could probably do several webinars just on that law. But in the meantime, if Stephanie is ready to join us, I would invite her back to continue on with AI. Oh, Steph, you're on mute.
Thank you so much, Teresa. Apologize for that. Kathy, you can go to the next slide, please. So the key takeaways for this AI guidance from the Department of Labor are ultimately this. Employers are going to be responsible for providing human oversight when using AI programs or automated systems. So although there's a recognition that AI systems and programs might be helpful, they might be efficient, don't rely on AI exclusively to get it right. It's not going to be a defense or excuse to violations of, say, the Fair Labor Standards Act, the FMLA, or other laws that we'll go over briefly. And what this guidance does is it intends to issue spot kind of where AI might get it wrong or might result in a violation of one of these laws that the U.S. Department of Labor enforces. So don't rely on AI for matters that should not be rigidly applied, right? Where there is a human nature of evaluation or consideration on whether, an extension of time should be granted for purposes of, say, the FMLA certification process, or something like that. Ultimately, right, the key takeaway is really going to be that human oversight is going to have to necessarily be involved for ultimate decisions regarding hiring, promotions, discipline, or application of a lot of these laws, to make sure that even though you have some sort of AI system that might be helpful, that it's not resulting in a violation. Next slide, please. So briefly, one of the issues, one of the topics that the guidance covers is the Fair Labor Standards Act. And the Department of Labor addresses or identifies a couple different ways that the FLSA might be violated when AI programs are used. For example, there are AI programs that are used for tracking working time, where the program identifies maybe if someone's not working or idle, cursor tracking or that type of program. Reliance on those monitoring systems without proper human oversight might result in a failure to pay wages if that time is being counted as not working time, right? So an employer has an obligation to ensure that employees are getting paid and tracking all hours worked correctly. Next slide, please. Another example would be monitoring break time. Still similarly, so the guidance reminds employers that breaks of 20 minutes or less are generally counted as hours worked and have to be paid and counted towards overtime. So these smart entries or auto-populated break times that might be involved, and I think these are common. Sometimes employers use systems that automatically deduct 30 minutes of break time throughout the day at an arbitrary period of time. That could constitute a violation of the FLSA if it's not accurate, or if the employee is not actually relieved of all of their duties during that break time, right? Then such break time would have to be paid for those non-exempt employees. Another example of where this could go wrong as well with use of AI is during waiting time. The guidance addresses, right, the difference between being engaged to wait. If an employee is being engaged to wait, that counts as hours worked and has to be paid. Or if they're waiting to be engaged, right, that distinction, that is not hours worked. So AI programs that assign tasks automatically if employees are waiting for tasks or not waiting or something along those lines, right? That time, it might result in an underpayment or inaccurate tracking of time and counting of hours worked as well. Next slide, please. Work performed at multiple locations. Another example that the guidance provides, or this field assistance bulletin provides, is the use of location monitoring systems to track employees as a basis to determine if the employee is working, right? If you have some sort of physical tracking device that might use or connect to an automatic clock in or clock out process, that might also result in an underpayment where the system fails to account for all the work performed in different locations, right? So one of the examples that's provided in the guidance is, a construction worker might actually begin their workday before they actually arrive at the designated work site if they're required to go pick up tools at the company headquarters or facility or purchase supplies before they head to the official work site, right? So that time might not be captured depending on the programming of the AI or the location monitoring system used. Another example would be calculating wages. There's use of AI to calculate wage rates. One of the biggest ones is the regular rate. Remember that the regular rate is not just necessarily a straight hourly time or rate of pay, right? It includes things like commission, shift differentials, non-discretionary bonuses, if someone's being paid piecemeal, right? So use of AI to calculate wages might not necessarily be accurate. It's going to depend on the accuracy of the inputs. So making sure that those things are accurately calculating and not, thinking that they're smarter than the law and what's required to be calculated into those regular rate calculations for purposes of overtime. Or even, if it's piecemeal, right? Not just overtime, but piecemeal calculations, right? Making sure that however it is used, whatever the system does to count for how an employee is getting paid, if it's on different rates of pay, that is accurate and not using some sort of algorithm to estimate, because that could result in an underpayment. Next slide, please. Okay, so another topic that the guidance addresses is the Family and Medical Leave Act, the FMLA, that the Department of Labor also enforces. So it identifies, a couple situations where use of AI systems might also result in a potential violation for FMLA, and kind of, heeds a warning to employers as such. So for processing leave requests, right, eligibility and timekeeping, right? So similar to our discussion on the FLSA segment or section, right? If the system is not accurately counting time or hours worked, right, then it might result in an employee being determined that they're not eligible for FMLA if they don't meet that 1,250 hours threshold or service hour requirement. So it might, if it undercounts, right, it might result in a denial of FMLA or eligibility incorrectly. So kind of a domino effect there. Another example would be certification to support FMLA leave, right? Automated systems that have certain programmed rules for FMLA certification might result in asking an employee to disclose more information than is permissible under the FMLA, right? Another example with respect to certification would be setting those 15-day deadlines or an improper or overly rigid treatment of the 15-day deadline to provide the certification for purposes of FMLA, right? There might be certain circumstances where an employee can't comply with the 15-day deadline, and that extra time for submission of the certification would be appropriate. So kind of, again, going back to that early slide, right, where there's that human nature or aspect that you have to really consider all the facts, and these bright line rules are not going to be conducive to these types of assessments, right? Next slide, please. With respect to interference and retaliation, AI systems that track and analyze leave use against those rigid, tracking or rigid application of certain workplace rules. Reminder that employers cannot use AI systems or cannot retaliate against FMLA users for taking FMLA leave or discouraging. They can't discourage the use of leave. You can't count FMLA as a negative factor in employment decisions like promotions or disciplinary actions, or assess, attendance points for those protected absences. That would be or could constitute a violation of the anti-retaliation provisions of the FMLA, or denial of benefit to employees who use other similar types of leave. So when AI systems are used in this, application, right, if you're counting attendance, absences, et cetera, then, ensuring that whatever rules, again, the AI is only as good as the input, ensuring that FMLA leave users are not being retaliated or discouraged, right, and that they're not getting those negative points, attendance points for those protected absences. Next slide, please. With respect to the PUMP Act, right, remember that's the federal law that went into effect last year that provides an expansion on break time for nursing employees in the workplace. So similarly, again, use of AI to track or make determinations on employee work hours, schedules, assignment of tasks, et cetera, might result in a violation of this PUMP Act that is necessarily going to be very unique to the employee, right? The length of any break, frequency, timing of breaks are all going to be really specific to that employee, and they might evolve over time. So AI systems that are going to apply a rigid establishment of work schedules, assignment of tasks, when they can take their breaks, et cetera, might be a violation of the PUMP Act if it's not going to work with that employee to figure out what works for that employee and what the employee reasonably needs in terms of that. Similarly, relatedly rather, productivity scoring or monitoring systems that penalize an employee for failing to meet certain productivity standards or quotas because they're using these pump breaks would also violate the law. Or automated scheduling systems that require makeup time. An employee does not have to be, cannot be required to do makeup time when they're using these pump breaks or taking these pump breaks. So that could be unlawful retaliation. Next slide, please. I think we're, at the end here. The last, piece to the guidance or to the Field Assistance Bulletin was a brief discussion on the Employee Polygraph Protection Act. And that's a law that is in place that prohibits private employers from using lie detector tests on employees for pre-employment screening, et cetera. So use of AI technologies, similarly, that have the ability to use eye measurements or voice analysis, micro expressions to suggest if someone's lying, use of AI is not a get around this EPPA prohibition. So, the long and the short of it is ultimately, right, you can't use AI to violate any of the laws, and you certainly need to have proper human oversight to ensure that you are complying and meeting your obligations under each one of those laws and getting it right.
Oh,
And I know we're right on time, but with respect to retaliation, like I mentioned, you can't use AI to take adverse employment action or violate the law, right? It's not an excuse. It's not going to be a defense. AI did it, not a person. That's not going to be a defense to the employer if it results in a violation of one of these laws or retaliation. Now I think it's really back to you, Teresa.
okay. Thank you, Steph. And thank you everyone for your attention today. Please feel free to reach out to myself or any of our panelists if you have additional questions. We're thrilled that you were able to join us, and we hope to see you next week or at one of our workplace conferences soon. Thanks, everyone.